Hi guys, thank you Prakash sir and the trust for calling me. Am I audible? Yeah. Okay. So let's try and keep this as fairly practical as possible. There is no point talking about citations in a theoretical manner. So just now when I arrived here, sir and I were discussing the Darukand matter, which was also mentioned while they were introducing me. Now, one of the arguments, for instance, which we had made was about the affidavits, formal affidavits which had been given as evidence and what was the evidentiary value. Now, when you're researching a question like this, right, we had to answer whether it could be relied on by the court, whether it could not. So the question always becomes, where do you begin from while trying to answer such a question? So the first place always has to be the bare act, right? No matter what subject you are talking about in law, if the constitution or the bare act speaks about it, you have to begin by reading the bare text, right? Then the next question becomes, how do you interpret that? How do you understand? Where do you go from there? So then the next answer is commentaries. Now, all of us have commentaries. Criminal lawyers regularly rely on Sarkar, Ratan Lal, Dheeraj Lal, etc. But how many? I'm guessing the entire audience here is law school students. Yes. Correct. None of us, at least we were never taught in a classroom how to read a commentary. Right? We are told कि हाँ जाओ commentary पढ़ लो. So and so section पे 10 section का आप commentary पढ़ के आना. आप exam के लिए commentary भी नहीं पढ़ते. Normally we have those which are those shortcut guides. Guide पढ़ के हम लोग चले जाते हैं. On each section there are about 1 page, 1.5 page. That's all. Right? So the first thing I actually want to do is to show you how a commentary is structured and how to read a commentary, because they are not actually structured. I brought one with me. I'll just pass it around. They are not structured like regular books. Right? A normal book you would see has an index at the beginning, right? Where even these do, where you will see the table of contents will have section 1, section 2, section 3, so on. But there will always be some subjects which are not, you might not know what section, first thing, right? ठीक है, आप Google search करके you might even figure out what section is relevant, but you might not know them all, right? So your table of contents, and that's actually the correct term for the index at the beginning of the book, because there is another index in every commentary at the back, right, which is in alphabetical order by subject, and that is far more extensive than your table of contents at the beginning, because the table of contents will only have chapter headings कि chapter 1 on section 1, chapter 2 section 2, because सब commentary में वैसा होता है, one chapter on each section, right? So if you know the section, great, that this is the section applicable to me. But what if there are multiple? Or what if you are talking about a subject which is not covered by a section at all? For instance, if you see something like cross-examination of witness, apart from one section saying that yes, cross-examination is permissible, Evidence Act and CRPC are silent. What is the meaning of cross-examination? How it is to be conducted? Even in that one section, the only thing it is saying that, okay, opposite party may put leading questions. But beyond this, how it interacts with the other sections, there is nothing in the Evidence Act. Which is where this index, if you see at the back, and now I'm going to pass it around, is very useful, because this has each subject along with all the several page numbers on which it occurs. So across the sections, every time when they're talking about cross-examination, or say something like eyewitness. Eyewitness is not a defined term, but the manner of appreciation of an eyewitness evidence will be very different from how you look at any other witness. A police witness will be treated in a very different manner, right? So look, I'm just passing the book around, take a look, pass it along. This is the index which is always there at it's called a subject index, right at the back of each of these books. So this is A. The other thing which I want to show you all from this book, and you all can flip it over when it comes around to you, is there's also a table of cases. Now, all judgments, of course, the best way to read a judgment is you read the entire thing, right? But if you all want to see how a commentator has treated a judgment, what are the various views that have been taken on a judgment, this will not apply so much to commentaries as to judgments, to books which actually talk about, which take a view of their own. So for instance, I'll give you a simple example. For constitutional law, most of you all use MP Jain or you all use DD Basu, right? These are two books which are only trying to tell you that these are the articles in the constitution, these are the various case laws on it. But if you see more recent books like Gautam Bhatia's Cornerstone Constitution, the Cornerstone, or if you take H.M. Sirvai's book on the Constitution, these are trying to argue certain things, that we think the Constitution is this, or that it's a living document, or that this is the manner in which the Constitution has been evolving. These are not trying to tell you Section 1 says this, Article 2 says this, Article 3 says this, right? They are actually trying to propound a view of how the Constitution should be read and interpreted. So in those books, this table of cases becomes very important, because then you can actually see which cases they have dealt with, what their view on those cases has been. So that index of cases is right after your table of contents at the start of the book, right? So whenever you pick up a commentary, it's quite useful not just to look at your starting index, your table of contents, but also at the subject index at the back, and in some cases the table of cases. Now the subject index at the back is arranged in alphabetical order, so A to Z. Similarly, your table of cases also is in alphabetical order, so case name starting from A all the way up to Z, right? So then after you've done your commentary reading, right, now the best way to read a commentary obviously is aapne uthaya whatever your section is, you've decided I want to read section 27 of the Evidence Act, for instance, and on whatever point you think you are researching, you note down A, what it says, B, you look at what cases are being cited, right? So when we talk about a citation, right, a judgment is not a citation, right? You can have a citation for anything. You can have a citation for a newspaper report. Citation is basically, the word means address. Very simply, citation is like saying address. So you can have a citation for Times of India, 15th April, page number 8. So when I say that something is found in Times of India, page 15 July, whatever date, that is the citation of that particular article, right? Similarly for a book or an article in a journal or for a case law. So citation is only that title, right? So for instance, if you say something like State of Maharashtra versus Gaurav Bhawnani 2020 bracket 1 SEC page 674, that is the citation of that judgment. The judgment itself is a judgment, right? So those could be judgments or they could be orders, right? We normally end up in court, a lot of us end up calling them citations, but actually citation only means address. So the way to read the commentary is obviously once you've read your subject, you've understood the broad basics, because the commentary will not tell you anything more than the broad basics. Then you note down what case laws they are relying on, and then the next thing to do, of course, is to find those judgments, read those. Then within the judgment, what other judgments are being cited, you keep hopping and skipping to the next one until you find the best judgments that would support your case, right? And to find a judgment also, it's not simply a question of, oh, this is a murder case, in this murder case somebody was acquitted. Great, a lot of murder cases have a lot of people in which they are acquitted, right? But why should that form good law for you? So you have to look at very specifics. So for instance, if I am trying to argue that there are two eyewitnesses in my case, but they are both relatives of the deceased, they both hate me, therefore I am trying to argue that they are interested witnesses, right? They have enmity with me. So the judgment which I find should have similar facts, right? Where there was enmity, where there were interested witnesses who were related to the deceased, and therefore they were held to be unreliable. Right? Just finding any judgment in which a murder case was acquitted is of absolutely no use, because then there would be thousands of cases, right? So the next thing we are going to do is I will take you all through some of the databases which are used for finding citations. I'll show them to you on the screen so that you all can actually see how to search for them, because a lot of these tools also, has anyone been taught these in a classroom? Okay, so let's do that, right? I will show the databases to you all. I will show the various sections, kinds of searches that there are on each of these databases. and then let's take it from there, right? And then if you all have questions, then we can just do question and answers at the end of it. Is this on? Oh, perfect. Hang on, just give me one moment. Actually, can you switch it off for a second? Oh, wait, I'll just disconnect it for a second. Hang on. While I log in, and then I can switch it back on. Ganesh, someone here? Yeah, can you? Is there Wi-Fi here? Because I can't seem to connect to the. Otherwise, I'll just do a hotspot. Yeah. So, if you all will have access from your colleges, I hope. If not, please tell your colleges to buy you access. So, basically, what happens is when judgments are written, right? So, there are hundreds and thousands of judgments written every day across the country. Now, judges normally have the option to say that this judgment should be reported. So, I'll show you that on the Bombay High Court page also. There's a section called a reported judgment section, right? Where the judge themselves says that, look, we think we've decided an important question of law, and so they decide to report the judgment, right? So, this recent judgments button, and there's another, one second. Where is this? I'll just look for it and I'll show it to you all. Here. So this is reported judgments and orders, right? So see, now especially nowadays with this India Kanun, I think a lot of you all must be using India Kanun because a simple Google search also throws up India Kanun judgment. But what you all would have seen that India Kanun quite often also has things like counsel for petitioner came and asked for adjournment, hence adjournment granted. Now, normally back in the day, people couldn't even access orders like these on the internet. And you were never supposed to. I mean, sure, it's good that they are online. Everybody should be able to see what's happening in proceedings. But they are frankly useless for you and me. किसी कोई random matter में adjournment हो रही है उससे हमारा क्या लेना देना, right? या अगर कोई बहुत specific fact situation पे कोई judgment decide हुआ है, again, it's of no use. So whenever they decide a question of law, judges are expected to say that report this judgment. Right, so then it gets uploaded to this section, right? And there's also a couple of markings they make on the judgment itself, which are very subtle. I won't go into all that, but वो यहाँ आती है, right? And then all these law reporters. So you have AIR, SCC, Taxman, Criminal Law Journal, right? जिनकी ये citations होती है. CRI, LJ is Criminal Law Journal, for instance. AR and SCC use their own. Then there's SCR, Supreme Court reports. So there's a bunch of these, right? So they look at the judgments from here. For Maharashtra specifically, you have BOM CR, which is Bombay Crime Reporter. Then you have all Maharashtra, right? So these guys keep an eye on these, and from here they pick them up, right? And so initially, the correct way of doing things was that you only ever use those judgments in court which have actually been carried in a hard copy in a bound volume of one of these reporters, right? And even today, in an era where everything is getting uploaded online, only those judgments which these reporters have carried, right, will get that citation of 1 SCC 472. Because like I said, that's an address, right? So a citation, let's take for instance, somebody call out a name of a judgment. Give me any name. Anyone? Chalo. So when we go to Kesav Nanda, right? So this thing, right, 1973 4 SCC 225, like I said, it's the address. So 1973 is the year of the volume. 4 is the volume number, because each year there are about 8 or 10 volumes of SEC, and 2 to 5 is the page number, right? So even today only these count as reported judgments. And so if you actually go to the Supreme Court, for instance, they in every courtroom have the entire volume of SEC 2 sets lying in each courtroom. So when you say I want to cite so and so judgment, they actually ask the associate to pull these out and give it to them, right? So that particular volume with the page number will be handed to the judge, right? So you're only expected to honestly cite judgments which have been reported. Nowadays we give anything and everything. SCC online citation, we hand it over to the judge. People hand over India Kanun, right? But that's actually not the correct way of thinking. You're supposed to only hand over these judgments because this is what the judge themselves deemed. It's not that SCC has deemed that this is a great judgment, right? The judges themselves deemed that this should be law, right? Because the others might have been decided on some question of fact, so on and so forth, right? And ideally you want to be using SCC as opposed to the other reporters, because the Supreme Court itself tends to place greater reliance. Like I'm saying, they have copies of SEC lying inside their courtroom, right? Now let's see what next thing is, how these judgments are structured. Keshav Nanda is a little bulky, but theek hai. Anyway, so the beginning portion, right? So this is what is called a digest note. Please never hand this over. This is not the judgment, right? This is just a note on it, and that too on one very particular specific part of it, right? I'm trying to open the judgment. Let's see, it's still loading. But basically every judgment in SEC and all at the top has what's called a head note. Now the head note is not the judgment. Those are not the words of the judge, right? Most of us tend to initially only read the head note, understand what it says, kaam chalao. I've even seen judges cite the head note and reproduce the head note in their judgments. But frankly, that's an incorrect way of doing it, because the head note is not the words of the judge. That is what's written by the SEC editors, right? Where they're trying to give you a summary, trying to give you a brief idea of what all is said in the judgment, especially judgments like Keshav Nanda Bharti, which will have many things that they've spoken about, right? So a head note is good for you to get a general idea and to be able to find things in it, because if you see every head note at the end of it will on the right hand side have certain para numbers, right? So that will actually be leading you to the paragraphs where that particular subject is discussed. So for instance, if there is a judgment, let's say, I'll use criminal law examples only, it's easiest for me, where for instance there is one recovery panchnama under 27 of the Evidence Act, there are 2 eyewitnesses, there is CCTV footage. Now I want to see how the judge dealt with the CCTV footage, right? So I'll go to the head note on the CCTV footage and see the para number, and that can lead me directly to the paras quickly, and I don't need to waste time reading the entire thing if I'm in a rush. Ideally, of course, you want to be reading the entire thing, but if you don't have the time, that's actually the utility of the head note, right? And if you're using a soft copy, you will see that when it loads, that actually the para numbers are in the form of a link, so you can just click and jump to that place, right? Okay, this is not loading, guys, sorry, this is taking a bit. I'm just going to open another tab till then so that we can move on to something else. Hang on. खुल जा भाई. Something else opening. हाँ. Okay. ठीक है, till SCC loads again. I don't know why it's taking this long. Let's actually dial back a couple of steps, right? We'll come back to SCC, but till it loads, right? Even your normal basic Google search, it's great to do a Google search at the beginning. It gives you a broad idea. It points to the right direction, sort of, right? You don't bank on it. Never cite Google, never cite Wikipedia in court. But to give you an idea of what direction you need to be searching for things in, Google is great. But even Google, again, has a bunch of things, right? So now, here we are, right? So this is Google Advanced Search. Now you can do a lot of these things from the main Google page itself, but it's a little tougher. Here it becomes easier because you have all these columns to fill this into. Now, for instance, yesterday somebody had called me and they asked me for which Maharashtra DCP committed suicide a few years ago. Now the thing was, normally what would you do? You'll go to Google and say Maharashtra DCP suicide and enter, right? So here's the results we'll get for doing that, right? Let's just do this practically. And you'll see a lot of results, the first 5-7 results in fact, are all about Himanshu Roy. Yeah, but Himanshu Roy was not the person we were looking for. So now if you were doing this in an advanced search, so keep in mind that when you're doing a normal Google search, it's doing an AND search. Basically, it's trying to look for all these words which I've typed into my keyword search, right? It's trying to look for all of them to be in the article, right? Those articles which have all these words in it will be placed highest. Then they have their own ranking of, okay, which sources are considered reliable. They generally place Wikipedia high up. But what a Google Advanced Search will allow me to do is do the same thing, all these words, DCP, Maharashtra, ATS, but I don't want Himanshu Roy because Himanshu Roy is not the guy I'm looking for. No, wait, I've written DCP. ATS nahi, suicide, no, was our search. Correct. Now we've kicked out. Here we are. Suddenly, we have articles about a completely other set of things, right? So you have, what do we have? We have Sanjay Banerjee. We've got Shiv Sena asking for a probe into who's this. Okay, these are all Sanjay Banerjee. So suddenly Sanjay Banerjee has become our top hit. But now we can also eliminate Sanjay Banerjee if he's not the right guy, right? So Google Advanced Search basically allows you to do a lot more than, hang on, where is Advanced Search? Yeah, so you can also try and put in what kind of sources. So for instance, if you toggle these buttons, play around with them, you can say I want PDF files. So for instance, if you're looking for books, you can say none of these words, you can say any of these words, which makes it an either or kind of search. You can kick out Sanjay Banerjee also from this, right? So it allows you to do a lot more with Google than is normal. Now let's see if SCC has loaded. Also this and or thing, nahin, it's not loading only. Yeah. Damn it. Let's see. Hang on. Oh, chalo. At least we managed to come back. So this is your home page for SCC. So your search is your normal keyword search, but has anyone taught you all what a Boolean and or search is, near, etc.? Have you all been taught this? Okay. So now when you click on this button, if you can see this button here called Boolean, right? This is there in 90% search engines, including Google. Except in Google, I took you all to advanced because it sort of lets you all do that through those bars. But most places don't have those bars, right? Yeah, SCC is really hanging today. Anyway, so this button Boolean is what allows you to do various kinds of keyword searches, right? So you can say Gaurav and Bhawnani or Gaurav or Bhawnani. Now that makes a huge difference, right? So if I say Gaurav and Bhawnani, for instance, only those judgments or orders which have both words will appear. Whereas Gaurav or Bhawnani means only those which have either Gaurav or Bhawnani in them or both in them, right? So can you imagine the difference in the size of hits you are going to get, right? Because there aren't going to be too many. So this is how you do it, right? So you have to put them in inverted commas, and this works on every single search engine in the world, right? So this is, it's not like it's unique to SCC. So this is going to be common throughout all the search engines I show you all. I'll show you all Manupatra after this, Indian Kanun, which is what most of you all will use on a daily basis, right? So all this works even on Indian Kanun. And then I'll show you all an OR search. So this is going to throw up about 10 or 15 results at most, right? because it will only have judgments which have my name in it basically. Whereas if I do an or search, every single Gaurav to have ever appeared as a judge, as a lawyer, उन सबके सारे orders and judgments will start showing up. So then it will be thousands. Right? Now just imagine doing this with something, yeah, SEC is just not our friend today. But you'll get the idea. I wanted to practically show you all, but imagine doing this with some search, such as when you're trying to narrow it down, right? And this is what we normally use it for. You will begin with, for instance, if I'm trying to argue that an interested eyewitness,
AIR online, I haven't.
if you can, you just log it in, no? Or whatever, put it on that computer and put the projector there, that's also fine. Log in here. So, we can do this in Google also. No, but he's doing it on AR, so I'll show it to you all with a legal search, right? So you all will be able to understand the impact. So normally how you do it is you start a search with Section 27 Evidence Act Recovery Panchnama. So that will give you say 10,000 results. But I don't want everything under the sun on Recovery Panchnama. For instance, I'm trying to make an argument that the Recovery Panchnama is bad because let's say the facts were already within the knowledge of the police, or they were not within the exclusive knowledge of the accused. So I will add the word exclusive knowledge, right? So I will put an and search and add those words. So then from 10,000 hits, I will come down to 1,000. I'm going to show this to you all once we have a login. So it will make a little more sense to you all. But that's actually how you end up finding the judgments which are relevant to the exact point you all are trying to make. Because otherwise it's very easy to get lost in the sea of thousands and thousands of judgments, and it's impossible to read every one of them. Yeah, 2 second password mat dekho unka. Look at me. Nahi na? What a shame. Perfect. So, the phrase we were discussing, right? So, let's say 27 recovery. See here, instead of making me enter and is already there, like it's giving you an and or option, right? With SEC, it's a little nicer in the sense that I can mix and match and or in the same search. You can also do what's called a near search, which I'll come to after I'm done with and or. You can do what's called a near search. Chalo bhai. Let's give this also a go. Let's see. Yeah. So actually, this is the thing, right? See, here's the number of hits we've gotten as of now. We have 12,616 results, right? It's absolutely impossible for any human being to sit and read 12,000 judgments on 27 panchnamas and for it to make any sense at the end of it all, right? So now if we were to search within these results, right? So if you saw on the SEC this, one of the arguments we make quite often to discard these panchnamas is that it was from an open place. So now if I add open place to this search, you will suddenly come down. I hope it's within this search. No, wait, we are not within the search. Hang on. Right, so let's do it again. 27 recovery. No. Hang on, let's just do SCCR.
Actually, AR works in or itself. It doesn't in.
It doesn't work in AND?
Yes. That is why SS is not.
No wonder. Hang on, no, let's do it this way, no? Proximity is also not working. That's the problem. No, so in fact here if you see on SEC for some reason on AIR, okay. Now I've put too many terms, right? So at this point I've reached a point where they are not able to give me anything. Let's just try knowledge. What a day for SEC to go down. No. Wait, let's see. I'll just try to go to Manupatra. Let's see whenever it loads. ठीक है. Wanted to finish these and then move to the next thing. Here we are. Brilliant. So actually Manu has the best of the search engines for all of these. Let's see. What was the experiment we were trying? Recovery 27 and accused. Right? This was our initial search. So Manupatra, guys, if it's a little expensive, it's also it's got the best search engine, but never rely on it in court because they manually type in their data. And we've had occasions where this guy who was typing put in a text message to his girlfriend in the middle of a judgment and then continued. So he forgot to switch tabs, and so in the middle of a judgment you have a message to his girlfriend. Okay, so what we have now for our first hit is about 49,000 results, right? So now if we search for, say, open place, right, which is a very common argument made against 27 Panchnamas, that was from an open place. So this will bring us down, it should bring us down by about 20,000. Oh, ja bhai. Oh, by a lot. So we came down from 49,000 to 1200, right? So far more manageable. Now, if we don't want only those judgments which make a passing reference to this, which actually argue out the point, right? Why is recovery from an open place bad? Has anyone studied 27 yet? Okay, anyway, so I'll give you all a brief background for this to make sense, right? It's when an accused makes a confession to the police, normally that is not admissible in law in India, right? But if as a consequence of his confession, he says that I murdered Gaurav, I'll show you the knife with which I murdered him. Come, I'll show you where I've hidden the knife. So then the finding of that knife, or what we call the recovery of that knife, is admissible. Even though him saying he killed me is not admissible, him showing the knife is admissible. Then you can draw your conclusions from that, right? So the argument that we often make is that the knife, right? So this comes from the fact that the confession should have been within the exclusive knowledge of the accused and it should not have been known to the police beforehand. So if you want judgments where this point is actually argued out, so now you put in another keyword, right? And this will bring us down from 1200 hopefully to a couple of hundred. so on and so forth. Then after this, I'll add the word exclusive until I reach a manageable data set, until I reach about 30, 40, 50 judgments, which I can actually 627, right? So now I will add exclusive. Then when I'm left with 30, 40 judgments, I will sit and actually read those, because until the point where it's 600, that's impossible for me to do, right? So you bring it using all these keyword searches and or near. Now the difficulty now, for instance, with using a word like exclusive, right, is that it might not have been in the context of the recovery, because a word like exclusive could be used several times in a judgment in various contexts. It's a very common English word, right? So which is why you've got this thing called a near search, which I'm not sure if Manupatra allows, but let's go and try it anyway. Right? A near search is basically to say that all these words which we use, all these keywords, should be near each other, as in they should be in the same para or within 25 words of each other. That's normally the parameter for how much near means. Means that they should be within 25 words of each other. So therefore, only if this discussion is happening in a common context, right, will they be used there. And it will not be कि exclusive किसी और चीज के बारे में बात चल रही है, right? क्योंकि exclusive could have been something like, I said, the accused said that whatever, the deceased said he has exclusive rights over the land, and this led to their quarrel because the accused said no, it's a shared land, and therefore the murder took place. And then later they are talking about the 27, right? So the use of the word exclusive, even though it helped us narrow down our search, actually had nothing to do with why we were trying to narrow it down, which is where a near search often becomes useful, because then all your words are actually being used in the context and in the meaning that you were intending, right? So that's a near search. We'll just, to experiment this, all the words which we'd used, we said 27, recovery, open place, what else had we put? Exclusive and knowledge, right? Now if you see, the default here is near each other is all, which means that anywhere in the judgment, right? So now let's bring this down to 20. Last time we'd ended up with 169 results. This time I think we'll be below 100. Right? Let's see. The whole idea of all this, as much of course, is to find the correct judgments, is to be able to find it. Because when there are 10,000, nobody can read that much. And especially on litigation deadlines, you get a day, 2 days at most to prepare for a hearing, right? It's not like you're in the US where you have 6 months to prepare, you have only one matter to do. Right? Those law firms work that way. They have the time to actually sit and read every single thing. For you, you have to work smarter, you have to be quicker about how you go about looking for these things. ये क्या हो गया? Databases are really not our friends today. Sure. Got logged out. Oi. Anyway, if we manage to log back in, we'll do that experiment again, just to show you all the point I was making. But basically, those are the different ways of searching, right? Now your most popular databases, of course, there's SCC, there's Manupatra. Both of these are paid, they're fairly expensive. Normally you will have access to them through your law schools, or I mean, I still use my law school account, if you all can tell that I was logging in from my college ID. Because these are fairly expensive, right? So mostly bigger law firms will be the ones that have them. AIR has now launched theirs, which you all saw. Apart from these, of course, then there is the major free one, which is Indian Qanun. Right? The major drawback of Indian Qanun, like I told you all, is that it throws up everything. Indian Qanun does not use this filter of we will only use good judgments, reported judgments, etc. सब कुछ जो मिला उनको वो डाल देंगे. So sometimes that's great in the sense that they also have district court orders and all, which these bigger ones don't carry. But it will also have adjournment orders, and so their search gets very cluttered because they'll throw up too many results for everything. So it becomes a little difficult to use. Second, they're not considered great to be handing over in court. Otherwise, in terms of how to search and narrow down searches on Indian Kanun, the principles are largely the same as the other two, which I just pointed out. Yeah, apart from these, you've got some other handy links which you all might want to know in life. There is now the entire Constituent Assembly debates have been uploaded and are free to, like, with text searches on this great site. Hang on, I'll just go there so you all can copy the link. I'm not going to deal with, this is the link if you all want to write it down or take a photo or whatever. The entire Constituent Assembly debates, which otherwise, if you all have seen, I don't know, in your law schools, there are about some 15 volumes which take up half a room. So these guys have put it all online and it's searchable, right? This is a fairly useful link. Another useful link is in Maharashtra, they upload all FIRs on this link, this one. This is also taking a moment to load. I don't know what's happening today. The published FIRs. Yeah, then there is another where Maharashtra government uploads its government resolutions, which is useful, right? Apart from these, can we switch off recording for a minute? Yeah, and where is Indian Law Review? 3NF. Yeah. So these guys are writing primarily on Indian law. So it's some of the best scholars in the world on working on Indian law, except each article is for like $30. Right? So, but except all their articles either get uploaded onto LiveGen or on SkyHub. So it's great if you all actually want to use this for research for whatever reason and don't have $30 to give for one article. Now you all can resume recording once I shut this link. Yes. But that also comes in their higher end packs and whatnot. Then there are also other databases like Westlaw. There's Westlaw Classic, there's Westlaw UK. Again, you will primarily only have access to them while you are in law school. It's very, very unlikely once you all graduate that any law firm you all join will even be subscribing to these, right? So after this, the only way really for you, unless you figure out your way around, unless you figure out your way on, for instance, if I was not from India, I wouldn't really know how to use the Supreme Court website, the Bombay High Court website, how to do searches on them would be impossible. I wouldn't know that Indian Kanun exists, right? So similarly, when I want to search for case law from other countries, it's a little difficult for me to figure out which is their reliable, free database and whatnot. So in general, there's this thing called Common LII, which has for each country, right? So for UK, it's DALII. So they've got a whole series. So for each country, so you can just come to this landing page and look at their list of databases, right? So they've got one for practically every country in the world, or like every major country in the world, right? So you come here and then you can do again our normal searches, and to some extent you'll be able to find foreign judgments through this. They'll also give you fairly reliable copies in case for whatever reason you need foreign judgments, and of course you will not have access to, say things like Westlaw. So this is your go-to place. Now the only thing I wanted actually to show you all is, this is not working. Yeah, sorry guys. Otherwise I actually wanted to show you all the different kinds of searches also on these databases, apart from the and or and whatnot. See, because, yeah, sorry. Here we have, see, yeah, because see, there are things like citation searches, right? So I've never used this one. Judgment.
Firstly, go to the home page.
We've been logged out again. Okay. Basically, SEC and all, and I'll show you all from the landing page only if possible. If you already know the citation, there's a button called a citation search where you can just enter the citation. Like I said, it's an address, right? So you just tell them, I want to go to this address, and will directly throw it up. Then there's another thing which is called section search. So you can tell them this act, this section, right? And then it will give you every judgment from that act and on that section. right? Which might not be very useful for when we are talking about, say, something like 27, which like every criminal law judgment will have that. But if you're talking about some very specific section like the one we opened with, right, where we were saying that evidence was led by affidavit, which is not something that's normally done in cases. It's a very rare process. You can just say something like section 294 CRPC, and you will only end up with about 30 or 40 judgments, right? So that's very useful if you are looking for a very niche area where there is not much work, where there are not too many judgments, and you want to say everything that has ever been written about that subject. Yeah, and then the last thing I will do is I'll show you all a head note. I'll just do that from some downloaded judgment on my computer, because it will be the same thing except for the fact it won't be a hyperlink. ठीक है, रहने दो, it's fine. I think you all get the gist. Oh, we have SEC again. No. No, hang on.
How to find exact case of the judgment? Because if the judgment is of 700 pages or more than more pages, so how to find exact case?
You cannot. There is no way of finding a summary, no? See, like I said, the head note will be written by some editor. There is only so much you can trust it. But beyond a point, the only way to know what it says is to read it yourself. And there are unfortunately no shortcuts in this profession.
And so one more that how to find the citations from CRM.
So if you see where's that commentary floating around? Whoever has it, just pass it to him. So wherever they're discussing something, they'll put a citation mark, right? So there'll be this chota one floating above the end of the sentence, which means this sentence is based on that judgment. And then so if it says number 1, right? So just pick any sentence, right? So here it says where the doctor failed to give his opinion about nature of injury, court cannot substitute its opinion. And then it says 61. And then at number 61, there are 4 judgments, right? So those are your 4 judgments which are on that point, right? So when you're starting your search, you begin by reading these 4, right? Then in those, if you find more useful judgments, you keep rolling from there.
Usually they are given as a footnotes.
As footnotes. Basically, that mark is called a citation mark, and what's written down is called a footnote. Some books have footnotes, some books have endnotes. Endnotes are basically where at the end of each chapter they will collect all the footnotes and write them there, instead of keeping them at the bottom of each page. Yeah? All good?
Please explain.
Sir, without subscription, which website we will be able
Indian
to
Kanun.
India Kanun.
That's all.
In start, you told that India Kanun is also uploading judgments such as
They do.
day-to-day wise judgments.
That's what I said. So it's very clogged. I mean, you have to search a lot more in India Kanun to find the right thing. It's all there.
They are uploading judgments.
But they are just uploading everything. जो हाथ में है वो सब upload कर रहे हैं, right? Which is an issue, because then when you're doing a search, instead of 5,000 results, you'll start from 50,000 results. Then to bring it down to a manageable number is tougher, but वो मिल जाएगा.
So according to you, which website is the best?
SCC is the best.
SCC.
Also, because in court you should ideally be handing over SCC. In terms of search engine, Manupatra search engine I think is better, but in court you can only hand over SCC, so might as well use SCC. I've had senior advocates, designated seniors, I've given them Manupatra copies, they've said, no, please you bring SCC copy, otherwise I'm not handing it over in court. In the library, yeah. Yeah, I see. If you see in the so on SCC and Manu and all, they've got this button called True Copy now, which is where they've actually uploaded the Xeroxed copy of the judgment onto their website. So ideally, you want to be giving that. you ideally want to be giving the Xerox from your library, but because we all don't want to spend the time to go to the library, SEC has done that for us now, where they've uploaded the true print.
So can you explain them when the foreign judgments are cited and when are they relevant in the case when
See-
judges refer to those foreign judgments?
So his question is, when do judges refer to foreign judgments? So normally it will be on technical points, right? Or like say on constitutional law, where there isn't much decided before this. So you're more than anything else, you're not looking for, it's never binding on you what a foreign court said. You're trying to look for guidance in terms of, okay, how have other countries gone about this? So for instance, the recent judgment on 65B of Evidence Act, where we're trying to understand how electronic evidence works, right? Because we only have this one section in our Evidence Act and nothing else. Whereas England and all have enacted entire statutes to deal with it. So they're looking at it for guidance. Ki, okay, what exactly is electronic evidence? How does it differ from documentary evidence? Or if you see Keshav Nanda Bharti, whoever had started this, right? Keshav Nanda Bharti is based on a German doctrine, right? Which until that point had no head or tail in India. So if you read Keshav Nanda Bharti, before this there was no idea of a basic structure. The idea came from Germany, right? Which the advocates arguing at that point said that, okay, this idea makes sense that there should be certain things which are immutable, and it was put before the judges. But before that, we did not really have a recognized basic structure of our constitution or even this idea of a basic structure. So in such cases, you need foreign judgments, for which I gave you all that link.
So judges are also referring those judgments which are uploaded on the India Canon or any other website, or they have any certain other website on which they are filing.
They have access to SEC. All judges have access to SEC.
So they are taking judgment from the official website of Supreme Court or High Court, or
They all use SEC. That's what I told you. So in the Supreme Court, each courtroom, they have 2 sets of SEC books kept there.
they are also using SEC.
They all use SEC. Now, of course, they are starting their own search engine on the Supreme Court website, which doesn't work very well yet. And they've started this system of neutral citations, so that you can have your own citations which are different from the SEC or AIR citations. But until that becomes full-fledged, up till now, I think they've only done it for about 20 years. Out of our 75, 80 years, they've only uploaded 20 years onto the search engine of the Supreme Court, as per my knowledge.
When you started this lecture, at that time you told that the highlighting points which are given by the persons of that website are taken by the judges of the.
They sometimes do. I mean, I have come across judgments in which.
The lawyer has taken objection or he has clarified before the bench that.
How can we tell judges not to do it?
Highlight which has been.
How can we tell the judge not to do it?
Editors of that particular website is not appropriate or incorrect.
How can we tell the judge? But as students of law, we know it's wrong. See, that way the Supreme Court, if you search, has cited Wikipedia. But we know Wikipedia is not a reliable source. Wikipedia, you and I can go and edit any page right now.
We will be not able to tell, but there are senior counsels who have taken objection.
They have.
On that point, that
They have.
particular editor has not stated everything perfectly.
And they absolutely have. This has happened with me. See, in Sessions Court, I have had the courage to say it to judges where the prosecution was relying on a head note, and I told them the head note doesn't reflect what's in the body of the judgment. Please read the judgment. But if the judge was doing it, I don't have the standing to tell the judge, sir, aap galat kar rahe ho. Right? Maybe Pasbula sir, who was here before me, could have done that. He can do that in the High Court also. But that depends on your standing. No? Correct.
Sir, can you explain them the references which should be cited first as the order of citing?
यार वो तो पता है ने.
नहीं पता होगा basically.
Sir, there is one question.
हाँ.
Is artificial intelligence is helpful for finding suitable?
Ma'am, see, it's helpful, but you have to cross-check. I'll tell you why. There was one recent case in the US where a lawyer did an artificial intelligence search. He was given 2 or 3 judgments. He downloaded it also from ChatGPT, and he cited it in court. It turned out those judgments didn't exist. ChatGPT created them, right? And it looks very realistic. So it will have appeal number, case number, judge name, and it's a real existing judge. It's a real existing court, right? It had all the details which made it look realistic. It had facts. It had everything, but it turned out to be a fake judgment. Now, if you might think that okay, maybe this is only happening in the US and so on, this happened with close friend of mine, where client came to them on a point of competition, no, of non-compete agreements, saying that is this non-compete agreement enforceable? So he said no, typically in India, this has been the position with non-compete clauses, that they are only enforceable to this, to a very, very limited degree. Now, he said this, his senior said, okay, fine, write this opinion, send it to the client. They sent it. The client reverts to them saying, you all have not done your work properly. I found these two judgments which say that they are enforceable. So they went and searched. His senior called him, said, boss, you've not done your work properly. So he looked at what the client had sent them, looked for those two judgments didn't exist. And they had proper SEC citations, Supreme Court case number so and so, judge name so and so, all existing judges, existing lawyers claim to have argued the matter. Judgment doesn't exist. So ChatGPT is a little, it's a good place to start, like Google, but you cannot stop there. It can only be your first port of call, and then you cross-check everything it is telling you.
Is the client used ChatGPT?
Client used ChatGPT, and it gave him fake cases, utterly fake cases. So, and then thankfully, I mean, the advocates checked and then told him, I mean, ChatGPT is wrong, and then it ended fine. But imagine showing it in court.
During Bhawnani tragedy case, you have submitted a bunch of citations before the court. So, how many citations are appropriate for one certain fact to disapprove of certain fact?
Yeah, for 1 point, don't give more than 2 or 3, right? Because your same cheese 10 बार बोल के कोई फायदा तो नहीं है, right? And see, if it's from a strong enough source, give one. For instance, if I have a constitution bench of the Supreme Court saying something, right? There is nothing above that. Say a 5-judge or a 7-judge bench of the Supreme Court says something, they say this is the law. Now, what the Bombay High Court says after that, or what the Delhi High Court says after that, I mean, sure, it helps us understand it, but they cannot go against the constitution bench. So if I have that, I can only give that. I don't need to give 4 different judgments of different high courts to make the same point, right? Whereas in Bhawnani, if you remember, I had judgments from, say, Guwahati High Court, Delhi High Court and Uttarakhand High Court. I had nothing from the Bombay High Court, I had nothing from the Supreme Court. So I gave 3 to show that, okay, look, this view is consistent across high courts, right? That it's not an isolated judgment of one court. But you take those calls based on how strong your authorities are. But if you have one Supreme Court judgment which lays down the law, you don't need anything else. Done? Thank you, guys.